meeting with our SBA Live. We are super excited to have CJ Edgar here from Copper Canyon Law as one of our guests. Nikki, do you want to introduce yourself?
Yep. Hi, everybody. I'm Nikki Schmutz. I'm Director of Operations here at Full Circle. I get to work closely with CJ and his amazing law firm.
Yeah. And I'm Matt Van Dremelen. I'm the owner of Full Circle Aftercare. I get to work with Nikki and an amazing team every day. And we work with attorneys across the country. And CJ is one of the great attorneys that we are able to have assist families that when we find families that need help, he does a great job with that. So welcome to the show today, CJ.
Thank you so much. I'm excited to be here. This is what I do. This is my jam. So I'm excited to visit with you guys and dive into the complexities of all this stuff today.
Awesome. Well, let's dive right into it. So, as we are helping families with Full Circle Aftercare, we often, people ask us all the time, do you have to be attorneys to do what you do? Or do you have to get some kind of like legal permission to help families in the way that you do? And as I explain that to people, I always explain, no, we're not attorneys. We don't want to be attorneys. And I like my soul. I want to go to heaven. So no, but
oh no.
But we're not attorneys, but oftentimes we do run into situations where people ask us legal advice. And so, what are those questions? And so we're going to kind of run through some of those, and CJ can maybe help answer some questions that families would have, or even funeral homes or hospices might have as families are asking these types of questions.
Love it.
So, here, I'm going to do a disclaimer. So we have to do this for our purposes. Matt and I are not attorneys, so we can be on here and talk with CJ. We have him here for a very specific purpose to be able to share from his viewpoint as an actual attorney. So.
Right. Wonderful. So just statistics, less than 34% of American adults have an estate plan. And that's not really true, right? Like everyone has an estate plan. It's just the government has a plan for you, right? But 34% have something, at least what they think is an estate plan. And in that big national survey that DA Davidson did, 37% said, well, they don't really need one because they don't have enough income or they don't have enough money to need an estate plan. So CJ, is that true? Do you need money to have an estate plan? And when would you need an estate plan? When wouldn't you? What makes it necessary?
I love that question. So if you have a heartbeat, you need an estate plan. Okay. And that sounds like, oh yeah, you lawyer boy, you would say that, right? Well, that's not actually true. Here's the deal. Estate planning, one thing I've been really, really trying to educate clients on is we got to get away from this idea that if I have a lot of money, I need an estate plan. And if I don't, then I don't need an estate plan. Estate planning, this is my little secret. It has very little to do with how much money you have. It's all about who are you trying to protect when you pass away. So we got to get away from this idea that, oh, if I have a lot of money, I need some big, robust plan. And if not, it's all about when you pass away, who's going to be inheriting your stuff? And are we going to get it safely to them? Are we going to get it to them without having to get the courts involved? So, I mean, you could have $10,000 to your name and you need an estate plan. You could also have $10 million and need an estate plan. It doesn't really matter how much money. Who are we trying to protect? So what makes an estate plan necessary? If you own anything, then you need to make sure that there's some kind of plan in place on how to get it there. You and I both know $5,000 in the wrong hands can be very, very dangerous, right? I mean, giving $5,000 to an 18-year-old, that could be a very dangerous prospect. Well, most folks who are even contemplating a will or a trust, you probably have at least $5,000, right, to your name,
Right.
A life insurance policy, things like that. Man, that pays out to the wrong person. Big problems.
Yeah, I love that. And if you don't have an estate plan, like we kind of alluded to, the government's going to make sure an estate plan happens, right? And that process is called through probate. So another frightening statistic, over 1 million families every year have to go through probate. And that probate process is expensive. It's long. It's tedious. I mean, how long does the average probate take? CJ, do you know?
Great question. So a lot of people, a lot of people don't realize that one of the reasons why probate takes so long is that there's statutory requirements that your estate has to go through. So even if someone said, if I die, I've just got this one little asset that may have to go through probate. I don't care if it's one little thing or 20 big things. Those assets still have to go through the entire court process. So, for example, where I'm from, I'm in Arizona, but most states are going to have some requirement that a creditor period be ran, and that those creditor periods are never less than 4 or 5 months. So even the simplest probates out there, it's going to take about a half a year. And on average, statistically speaking, about 1.5 years is the entire probate process from beginning to end. So yeah, you can just kind of anticipate that. Mm-hmm.
Yeah. Oftentimes, when I'm talking to a family and it says it looks like probate might be triggered, well, I don't think so. There's just, why would that be the case? And there's only one kid. We're just gonna write it over to the kid. Well, you can't do that, right?
Right.
You can't just move it from one person to another, and that's when we get into like, what is those vehicles, right? How do we move assets when someone passes away? How do we know where everything goes? And I think that dives right into the will and the trust discussion. Nikki's running the slides here, and she's just right on top of it. I look over and that's exactly what she had. So, many families will think that a will is enough to protect them. Can you quickly tell us what is a will and a trust, and what are the differences between those two?
Okay, this is my favorite question. This slide right here. If you guys have a few hours, I can dive into this really deep. No, I'm kidding. Here's the deal. This topic right here is my favorite one to teach because it's the most misunderstood topic out there. And anyone that's listening today, I can promise you, I'm going to give you the answer that Google refuses to give you. Okay. So a will and a trust, what is the difference? I'm going to try to be quick, and Matt, Nikki, just cut me off when I'm talking too much here. Okay. So a will, this is so important. The number one question people ask when they call into our law firm, CJ, I want a will because I want to avoid probate. I hear people say that sentence over and over and over again. Yeah. You need to know wills are not drafted for the purpose of avoiding probate. Wills are drafted for the sole purpose of going to probate. That is why they are drafted. So when people call in and they say, I want a will because I want to avoid probate. No, that's what the purpose is of a will, is to go to probate. And so the purpose of a will is a written evidence of what your wishes are so that a judge knows what to ratify when you die.
It's the instructions for the judge.
That's exactly right. They're the instructions for the judge. And then probably the second most misunderstood thing in America, and man, if our customers and clients would understand this would make the whole world a better place. An executor of a will, the person you name to be in charge of your estate when you die in a will, they do not have authority to represent your estate until a judge ratifies that will. So until a judge gives you that blessing, that appointment to be the executor of the estate, you are just a nominee of that will. And time again, we hear people saying, my mom died. I have her will. It says that I'm the executor, but I'm marching around to the bank, to title companies. No one's listening to me. How come they won't listen to me? The will says I'm the executor. We have to slow people down and say, hold on. Has a judge appointed you yet? And they say, no. Then you are not the executor. Quit telling people you are. You have no authority until a judge appoints you. That appointment process, that's probate right there. That is what probate is. It's a judge getting you appointed so that you can go pay bills of the estate, collect bank accounts, sell the house, do final tax returns, all that lifting. That's what's taking the 6 months to 2 years to get all that heavy lifting done. And the court is overseeing it or monitoring it as you do so. That is what a will looks like as it goes through the probate process. So a lot of people say, well, can I avoid that? How can I avoid going through the probate process? That's when a lot of people are trying to put trusts in place. So that's probably the best segue of what is a trust, right? So
Sure.
A trust, oh man, if I put a trust and a will in front of you right now, you would look at them and you'd say, CJ, these look very similar. It's almost like they're saying the same thing, kind of, except for one huge difference. A will is just a wish list. It's just a written set of wishes that you want when you die. A trust, you kind of think of it like you're forming a legal entity. It is a contract. For example, my wife and I, we have a trust that we put in place for our kids. It says, we named it the Eager Family Trust. That's my last name. So the Eager Family Trust, and my wife and I contractually made a bunch of rules in the trust. It says that while my wife and I are alive, we own the Eager Family Trust. We can do whatever we want with the trust. We can buy and sell assets, do whatever we want. However, when we die, we have legally appointed my brother, Clay, to be the successor trustee of the Eager Family Trust. So because we have contractually appointed him in the entity, he does not need to go to court. He has immediate authority over the Eager Family Trust. And then in the rules of the trust, my wife and I spelled out exactly how, when, and where our kids are going to get all the assets of our estate. And so my brother never had to go to court. The entity was already in place, ready to go. And then here's the key feature of a trust and how it's different than a will. Again, remember, the will is just a written wish list. Once you sign a will, you just put it on the shelf and let it gather dust, right? A trust isn't that way. After you form a trust, the next big thing is you have to transfer your assets into a trust. So after my wife and I signed our trust, the very next thing we did is I deeded my house over into the Eager Family Trust. And then I went by the bank and I transferred my checking account into the Eager Family Trust. I called my life insurance company and I said, take my kids off as beneficiaries. And they said, okay, who do you want on as the beneficiary? I want the Eager Family Trust to be the beneficiary. Right. So for all of you who, if you are watching this and you can see my little fingies here, here's all my assets. When I die, they are not going to flow down to my kids. My assets are going to flow over to a trust. And then the trust spells out how the assets are going to flow down to my kids. And that is how a trust works. And that's how probably the big features, a difference between a will and a trust. A will most likely will have to go to probate. And then wills cannot hold assets for long periods of time. A trust can. That's why you hear people saying, yeah, they died, but the trust says their kids don't get anything until they're 35 years old. So the kids have to go to college or they have to go get a job and earn a living because the trust is prohibiting the kids from just being spendthrifts. Anyway, those are probably if someone asked for a Cliff Notes version, that would be it right there.
I wish everybody could hear that and know those simple facts. What is a will and what is a trust? And what, the will is a wish list. It's an instructions for the judge. And a trust owns the assets so that there's no change of ownership. And that is so important. And if people understood that, it would be such a gift to their kids when they pass away.
Amen. One thing that you should know that I would want the listeners to know, it's kind of important, is one thing that lawyers don't really like talking about, which I'm happy to talk with everyone about. And this is important. Not all wills go through probate. And I don't want anyone to have a misguided assumption that all wills go to probate. How can you avoid going to probate if you have a will? Well, because by the way, I'm an estate planning attorney. I do thousands of wills every year for my clients. So you're like, well, you're a hypocrite. You said they're bad and then you go do them for clients. No, here's what's up. If you get a will in place, and this is kind of a funny little sentence I tell my clients, our goal is to never use the will. We're going to put a will in place, but our goal is to never use it. How? Well, let's say hypothetically, I have a 90-year-old widow, and all she owns is she lives in assisted living, and all she owns is a checking account and a retirement account, an IRA. Well, she tells me she has 2 sons and they're adults and upstanding citizens and they have no drama going on in their lives. Well, what I'll tell that client is, you know what? At the bank, you can fill out a beneficiary form and that account will actually go around the will, and that beneficiary form will distribute directly to your 2 sons. And that retirement account, that has a beneficiary form. If you fill that beneficiary form out, that form will go around the will and straight to your 2 sons. So the reality is we actually probably don't even need to use this will. Now we're going to put it in place just in case you died and there were some loose ends out there that we didn't know about. But the reality is you don't need a trust. Those 2 simple assets, we can fill out beneficiary forms, get them directly to your 2 sons. We're hopefully never going to have to use the will in court, and off you go. You don't even need an executor of your state per se. So that is one way that you can avoid probate, even if you have a will. So don't be shocked if you go meet with the lawyer and the lawyer says, I think you just need a will. That's probably the plan they're developing right there.
Yeah, absolutely. Absolutely. Great information. Nikki, did you have something to add to that?
Yeah, so we have a lot of families we speak to who know there's a trust, but they don't have any of the documentation. Like it wasn't shared appropriately from one parent to a child or whatever the sharing needed to happen. And sometimes they think everything is in the trust, and we find nothing was ever deeded over into the trust. So they have this false sense of everything is fine and then are suddenly faced with the idea of probate.
Yeah.
It's scary.
Yeah, that's a really good point. So many Americans, they'll form these revocable trusts and then they don't do the second half, which is transferring the assets into the trust. Funny enough, if any of you are listening that have a trust, you'll notice in your set of estate planning documents, there's usually a little last will and testament that came with your trust. And everyone says, why do I have a will? I thought I did a trust. That's called a pour over will. And it's to cover this exact scenario. If you die and you forgot to put something in your trust, that little token will, that pour over will that we created for you, that's what we'll submit to the judge and tell the judge, whoops, we forgot a few assets here. That little will transfer the assets back over into the trust. So don't be surprised if you do have a trust and you find a will in that. That's probably what that will is doing. Yeah.
Great. And that'll lead us into the probate idea. What were you going to say, Matt?
I said, yeah, that's a great point. So, yeah, jumping into the probate idea of things. So I think we probably need to have a whole meeting, a whole nother SBA of just talking about how to plan and how to know what's best for me. And obviously, talking to an attorney is so helpful. Unfortunately, by the time we're helping families or a funeral home's meeting with the family, it's too late, right? Person's already passed away, and so they can't go back and write a will for their dad, and they can't put everything into trust at that point. So when probate's triggered, what we're hoping to kind of hit for the rest of today is what is that probate process? What can people expect, and how does it exactly work? So you want to kind of give a brief overview of that?
Yeah. So first and foremost, when someone dies and they either have just a will or they don't have anything at all, and everyone says, how do I know if I have to go to probate? So the way you'll know that you have to go to probate is someone passed away and you start identifying their assets, right? Like a house, a car, a checking account, savings account, retirement, brokerage, all those things. If we're always focused on title, that's what we're focused on. The titles of all those assets, were they just in that person's name? In fact, just before we started this broadcast here, I just met with a client. He called in. He said, yeah, my wife and I bought a house 20 years ago when we first got married. I was going through a bankruptcy, and so she just bought the house in her name. Well, we forgot to ever retitle it in our joint names, and she just passed away a few months ago. And I said, oh, yeah, so now the house title is just in your deceased wife's name. He goes, yes. And so we started talking probate. So that's the first way to identify, do we have to go to probate? Yes. If someone died and the titles of their assets are stuck in the decedent's name, that's the first little trigger that like I may have to go through probate, right? So we want to identify what assets are there and are the titles stuck in the decedent's name. If so, not to get too much in the weeds here, but there's usually a dollar value that those assets need to supersede in order to trigger the probate process. But for the most part, for the purpose of this visit here, we're going to say if an asset is stuck in a deceased person's name, you most likely have to go to probate. So what does that look like? If they have a will, this is why wills are so important. If you have a will, you can take that will to the court and the wishes are going to get executed according to the terms of that will. If you don't have a will, then it's going to be a person going and petitioning the court without anything in their hands. They're going to go to the judge and say, hey, judge, I think I need to be the executor. And the judge is going to say, says who? And you say, well, it's because I want to, I guess. And the judge is like, no, we're not going to. So then the judge is going to make you go get waivers from all other interested parties. And here's the crazy thing. If you can't get those waivers from all interested parties, the judge is going to say, no. We're going to make this a formal probate proceeding. And now you have to appear in front of the judge and make your arguments. And now you're paying lawyers lots of money. Okay. So that's another reason why a will is so important, is because if you have a will, it heightens the likelihood that the probate will go informal. You can just go give the documents to the judge, and the judge is pretty much going to rubber stamp them, more or less. That's another reason why a will is so important. So then, that's when it tees up that whole long process we were talking about: notifying creditors, paying debts, doing a public notice to everyone out there in the universe. Believe it or not, when you open probate, it's a public record. Your entire estate is now on public record. And so most people can't even believe that, but it's true. So that's kind of what's taken. And that's why it takes year and a half to go through that whole process. Yeah.
Yeah. I love that. Year and a half expect for that. The creditor piece is the thing that people don't understand. All the paperwork, right?
So much paperwork. Yeah. And when everyone, I laugh over and over every single time I get a new probate client that comes in. I say, okay, are there any known creditors out there? And without fail, they always say, no, there's no known creditors. And then I publish that public notice, and oh my goodness, over the next 4 months, I get emails or letters from Visa, from MasterCard, from Chase Bank, from Citibank. I mean, you name it. They all just start popping up out of nowhere. And I didn't know she had a credit card here. I didn't know she had this debt. And we have to address it now. And now the executor or the personal representative, they're having to address these problems. And that's what gets drawn out for months and months and months, because now we're negotiating with all these creditors and trying to decide if there's even going to be assets there in the first place. We've had some probate clients that by the time they got 6, 7, 8 months into it, they noticed all the creditor debts piling up. And then they looked at the assets of the estate. They're like, we don't even think there's going to be any money left after we pay all these people, to which case we have to tell them, you maybe would have been better off not even opening probate at all. Just literally lighting a match and walk away. I mean, that's almost what would have been better. And they're like, oh my goodness, this is a nightmare. This is all the stuff that we're trying to avoid so that you don't have to go through that whole process.
Yeah, absolutely. I love that. Okay. So let's jump to the next slide there. Why can probate be good?
Oh, yeah. Oh, and by the way, one last thing on that last slide, it said, what is the typical cost of probate?
That's a great question, actually.
Yeah, that's a good one. Good job, Nikki.
Thanks.
Here's the deal with the cost. And I told the Full Circle Aftercare team this. Again, I'm going to tell you stuff that most lawyers don't want you to know. So here we go. Everybody hold on to your hats. Probate technically doesn't cost that much money. Okay. Ultimately, if you're really just going to the court, you're paying for filing fees and document processing fees and things. Honestly, in most jurisdictions, you're looking anywhere from, I'm going to take a wild guess across the country. I can't speak for all jurisdictions, but $400 to $1,200 maybe total. Like, wow. that's really all it takes if you knew the process. But guess what? Most Americans don't know the process. And I laugh and this is horrible. This is demonic of me, because I have clients come to me all the time and say, can I just do probate myself? And I tell them, sure. In fact, I'll even show you what to do. I show them what to do. 100% of them, I'm not joking, 100% of them, they eventually come back and say, this is stupid. I'm just hiring you to do this. I said, I know, I'm sorry. And so what is the actual cost that you're paying for in probate? It's the lawyer fees that cost so much money, because we know how to navigate you and get you through that process as fast as possible. So what are the averages? You'll see anything. I've seen anything from like a paralegal doing this on the side for $2,000-$3,000. I've seen some law firms charge $15,000-$20,000. There's even some law firms in jurisdictions, like I know in California is popular. They charge a percentage of the estate. So, man, if they're charging 3, 4, 5% of the estate, and it's a $8, $9, $10 million estate, I mean, they're cashing out lots of money. And that's why you hear these probate attorneys in other jurisdictions. I mean, they do one big case and go retire. I mean, it's kind of crazy. So, I would encourage anyone listening, if you're finding a probate attorney, try to find someone that would do a flat fee for you, right? I mean, hey, flat fee service. Hopefully, it's a non-contested probate. You can usually get in and out for $4,000 or $5,000, maybe. I mean, it's not the worst thing in the world, but
yeah,
hopefully. And again, that's totally jurisdictional right there.
Yeah, I would say on average, not everyone shares with us this type of information, but the families we talk to, I would say 4,000 to 5,000. Yeah, depending on jurisdiction. Some areas definitely 5,000 to 6,000 is reasonable for a probate, for a simple probate.
And if you get to the far reaches of the coast cities, go coast to coast,
it's beyond that.
Yeah, double, triple that. But that's kind of what you're looking at in the country. So great question, Nikki. What does the cost? That's what you can look at right there.
Yeah, great. So why can probate be good? I saw this as the title of this next slide. Walk me through this, Nikki. You want to ask these questions?
Well, why can it be good? Sometimes you just have to go through the process, right? You can't access anything without doing the process, right, CJ?
Yeah. This is such a weird question, and it's such a good one. So good job. This is why this is kind of a unique question. There are tiny slivers of scenarios where probate is actually a good thing. Believe it or not, I've had quite wealthy clients in the past who said, I want to go to probate. Our family situation is so sticky. Blended family, stepkids fighting. I hate my stepmom. I hate my stepdad. Lots of infield fighting that the family, believe it or not, this is kind of weird. They'll form a trust and then they'll never fund it on purpose. So they say, I have the trust ready to go. It's locked and loaded. I've got my pour over will locked and loaded, but I'm not going to put anything in the trust. I want it to go to probate. And they want it to because they actually want the court to oversee it. And they say, I don't care how. Now, by the way, there's other ways to do that without going to probate. There's features and things you can do in a trust to make sure there's basically like a referee involved. It's called a trust protector. And it's very, very popular in America nowadays to have a third party overseeing the administration of the trust. But before trust protectors got popular, it was not an uncommon thing for someone to say, I do want to go to probate because I don't want anyone to feel like they can embezzle from the estate or do some sneaky stuff. I actually want the court monitoring this, and I don't care how much money it costs. I don't care how many lawyers get involved. So that is one reason, is because it's kind of hard to hide when the court is checking in on things. So I could see why someone would want to go to probate in that regard. Sometimes with like sticky custody issues with kids, some people want the court to be involved closely for custody of minor children and things like that. And I mean, your slide said it perfectly. It reduces the risk of fraudulent claims and fraudulent issues there. So yeah, it's not always the worst thing in the world. And by the way, I do try to preach probate is not the worst thing in the world.
Right.
I have plenty of examples where it was just a relatively, 5-6 month process. We were able to get the family on the right track and road within a matter of 3-4 weeks. The family didn't even know the probate was still going on because I was doing it all in the background.
Right.
And so, yeah, it doesn't have to be the worst thing in the world, but if you could avoid it, do a little advanced estate planning. Why not?
Yeah. Well, I think that one thing that a lot of families are scared of is that they're all going to be like fighting over things, right? Like that's what I hear. Oh, I'm going to have all my siblings in here going to be fighting. Well, probably not. Probably the attorney's
Right.
filing all the paperwork. You're never going to have to go to court. They're just going to go off what the will is. The judge is going to divide everything evenly, and you're not going to have to like go present a case of why you deserve your share of your parents' estate. Like that's not necessarily the case. So
Right. You're exactly right.
I love that. Good.
So-
So what? Go ahead.
No, I was just going to point out that the word itself, probate, triggers fear in almost everyone we talk to. And I think it's because of the unknown.
Yeah.
Right.
Or the idea that it's really hard. I don't know. What has been your experience? Why are people afraid of the word probate, the process?
Well, again, I'm going to throw my entire industry under the bus. We've done a great job at scaring you. We've done a great job at that. Of saying that. I mean, it's funny. I drive into work every day, and on the radio, I hear the ads. It's like that ominous voice, the same guy that uses to demonize politicians. It's that same voice, like you might have to go through probate. And that's kind of the general message that is out there in the universe. They're like, you might have to do this. And so that's probably why people are afraid. One thing I hear, and this is actually really important, your questions are just teeing me up for good thoughts here. I hear people say all the time, CJ, I have to avoid probate because if I go through probate, the government's going to take all my money. I hear that so much. Everybody says that the government's going to take all my money. For the most part, that statement is just absolutely not true. Okay. The government is not going to take all of your money. The only way the government will literally take all of your money in probate, or not even in probate, is if you died and they literally could not find a single heir in your entire family tree. I mean, we're talking the
Cousin.
entire tree.
Yeah.
They could never find anyone, and it went to unclaimed assets, and it sat there for most jurisdictions. I think it's like 7 years or something, and it sat there for 7 years. Then those assets, they call it's cheats to the estate, to the state, right? So that is the only scenario where the government is going to quote unquote take all of your assets. Aside from that, that's why I think I hear so many people come to me, CJ, I just got to get an estate planning. I know the government's going to take everything I have. And that's just, that sentence doesn't make sense either. It's not true. That's not how that works. So that's probably another reason why people are afraid. They hear people saying stuff like that.
Yeah.
There's a lot of paranoia that I've witnessed. But one real threat and a question I would have is, what if they didn't pay taxes for the last 20 years?
Oh, great question. So yeah, I mean, at the end of the day, that's another reason why probate can be, well, probate or no probate, these things have to be addressed. Probate just brings it really quick up to the surface. Like,
Right.
Whoop, like we have literally opened the door and said, come on in. That's what probate does. It opens a door and tells everyone to come in. So when you do that, yeah, you haven't paid taxes. I mean, someone's going to negotiate with the IRS for you. And so you need to be ready to negotiate that. And yeah, if the IRS is aggressive enough, they'll just say, no, we'll just start slapping liens on everything until we get our money. Right. Especially for our clients, a lot of our clients coming from hospice services, right? If you got on Medicaid or the state specific long-term care, part of that process sometimes involves them putting a lien on your house. If you're going to get on Medicaid, we're going to put a lien on your house. In the probate process, that's where they're going to settle up, right? I just had a client here in Arizona. We opened probate, and much to our surprise, we didn't even know this. the environmental department of environmental quality department of Arizona, unbeknownst to us, had this random little lien placed against the state. And the second we filed probate, they immediately put in this, it was a judgment. They had a judgment. The kids didn't know about it. And out of nowhere, they're like, what is going on? Turns out dad had a judgment against him from the state of Arizona from 15 years ago. And it's been getting compound interest this whole time. I mean, it's up to like $1.5 million. And so now we have hired a tax attorney to come in and start negotiating with the IRS on, like, can we get that judgment down? So that's we've started that. Yeah. So when you open the door, you'll be surprised who comes walking in.
Yeah. So on the next slide, I really like this question. What happens if I don't file probate? Right?
Yeah. So good question. So remember, the whole root of why we opened probate in the first place was because there's a title stuck in a deceased person's name. So if you don't open probate, you're never going to be able to transfer the asset. So by the way, that's a great question. There are some people out there right now whose mom or dad died 25 years ago. I mean, we're talking in 1998, mom died and she left me this house, and son has just been living in it for like 25 years. Right. And then out of nowhere. Yeah. And then out of nowhere, he's like, I'm trying to sell this house. What in the world's going on? And we have to say, well, when did your mom die? Oh, in 1998. Did you ever transfer the deed out of your mom's name into yours? I tried that. I remember back in 1999, I tried that, and this title company said I couldn't. They kept saying I needed letters from a court, and I just got tired of that, so I just gave up. Yeah. And I'm like, well, no, they were telling you to go to probate. That's what they were telling you to do. They need that court order from a judge that says you can administer your mother's assets. Now, 25 years later, we have to open probate. And so you can do it now or later, but you should do it sooner. Yeah. So do I really need to? But what happens if I don't open probate? The answer to that is you're never going to be able to transfer the asset. It's just going to sit there in the deceased person's name forever.
Right. And yeah, like if you don't have those assets, then you don't need probate. Right. That's the bottom line. So
yeah, we hear a lot of people call us and say, hey, my mom died. I think we're supposed to open probate, right? And I'm like, well, not necessarily. It's just because she just died doesn't mean you have to open probate. It's only if those assets are stuck in her name.
Right. Love that. So what happens if probate's triggered? They want to move those assets, but they can't afford to pay the fees. And
you know what? That happens all the time, right? There's folks who are like, well, I can't pay this $3,000, $4,000, $5,000 for a lawyer to help me. Option one is, okay, we'll start using your nights and weekends to start boning up on the probate laws. And by the way, not to disparage myself, you can do it. I mean, you can learn and you can get through the probate process. I mean, the court allegedly says we're going to try to make this easy for you. And there are forms online that you can find to do it yourself. If you're like, there's no way, I have to get help. Okay. Find a lawyer who will help you for an affordable price. And there are some lawyers, crazy lawyers, who will actually wait to collect until we have settled assets. It's the catch-22. You say, I can't afford it. But yeah, the whole purpose you're opening probate in the first place is because there's a valuable asset sitting there. So hopefully you're going to be coming into some money here really soon if you go to probate. On select occasions, I understand that. And I say, look, I'll go open probate for you. Let's get this asset in your name ASAP. And then you'll be able to liquidate that asset and pay me at that time. I hate to say this because I know credit cards are not the love of our lives, but another option is you pay on a credit card. Get through probate as fast as possible. Within a matter of a few weeks, you can have that asset in your name, and now you're cutting checks to the lawyer and paying off you're paying off your credit card 3-4 weeks later after the checking account gets put into your name or after the life insurance pays out. Just pay your credit card off at that time. So hate to say that, but that's something a lot of folks forget is, okay, you may have to put this on a credit card, but the whole point of doing, and a lot of people say, well, CJ, it's a house. It's a house. So I'm not going to have liquid assets and I'm keeping the house. Okay. Well, you may have to refinance. That's kind of the process of probate. You may have to refinance to get some cash out or whatever.
Yep. I love that. I really appreciate that.
Yeah.
So this next question, why do I need probate if I have a will? I think we already jumped onto that, right? So I
Yeah.
think that's a great point. You're not the executor. I love how you explain that. You're not the executor until the court gives you that authority, even if it names you as the executor. And then I think you've also answered this next question. Can I file probate on my own? Yeah, it's just not recommended. And I've literally had people try and come back to me and say, please help me find an attorney.
Right.
Because I don't know what I'm doing. And the court, they won't help you. They won't give you legal advice. So there's just no help for you if you're on your own.
You want to know what's something funny? I love what you just said, how the court won't help you. I wish the public knew that. The court literally cannot answer your questions. They will not answer your questions. They are not, they won't do it. And so they'll reject your filing and you'll say, well, why are you rejecting it? And they'll say, because you didn't do it according to statute 142513. And you're like, well, so what did I not do? And they're like, we just told you. And they'll leave you at that. Here's another frustrating thing. Oh, I hate to say this. Shocker. The courts are not infallible. And just this morning, right when I went into my office, there was a rejected probate filing. And I looked and they said the reason for rejection. And funny enough, it perfectly complied with the statute that they were rejecting for. And I just called the clerk up on the phone. I said, hey, you rejected this because of this statute. I said, it's in the first sentence. And they're like, oh, yeah, that's right. Sorry.
Oh,
Resubmit. But here's the crazy thing. If you didn't know that the courts weren't infallible, you would just be spinning your wheel saying they keep rejecting it for this. You don't even know that you did it right. And you don't even know that the court is rejecting you erroneously. And now you're really frustrated, right? So this happens actually frequently that we have to kind of gently nudge the court and say, you're actually the ones doing this wrong. And an everyday citizen wouldn't even know to call the court out on that.
Oh, right. Wow. Yeah. I just want to call out Pierce Dempsey made a comment. He says, amazing info here. So CJ, you're saying some great things and uncovering some of the things you say your profession normally won't say, which we absolutely love. So
thank you.
But I have a question. So this is a real family that we had come through here, and the mother owned a home, but it was basically condemned. And the daughter was like, I'm not going to do anything with it.
Yeah, that's that's very common. I just had a client here who, this is the weirdest thing. This was kind of before the housing boom happened again. And she did the math and she said, yes, there's equity in the house. She goes, I think I have about $30,000 of equity in the house. I said, okay. But by the time we added up probate fees, her realtor fees, and the taxes owed, it was going to be about even. She goes, so I'm literally going to go through this whole process to pay the IRS, to pay a realtor, and then to pay these fees all for nothing? And I said, yeah. And she goes, I think I'm just going to walk away from the house. And I said, yeah, I mean, you can. That's not just because you're her daughter doesn't make you legally responsible for your mother's house. And so she goes, can I just literally just walk away? I said, yeah, you can just walk away. What are they going to do? It's going to go through that whole process of an unclaimed asset. The bank is going to probably eventually just take it back as essentially a foreclosure. And sometimes sadly, that is the right answer. So yeah, if a property is condemned like that, there's by the time you get done with this whole process, the asset is valueless. Sometimes it makes sense just to kind of walk away, unfortunately.
Yeah.
Absolutely. Well, as we're helping families all the time and we are running into so many questions and so many issues that they have, we really can't give this advice. We're not attorneys, so we don't want to tread into the place of giving legal advice. And it is important for us to search for people who can help our families, right? And so we have lawyer partners across the country, but as we're searching for them, we often run into people who are not very helpful. And, you know, I think that the most nightmare one was I was looking for an attorney to work with in Oregon. And as I was interviewing him, I said, well, when you're setting up a trust, do you help the family in any way fund the trust or remove assets over? Do you give them direction on that? And he said, no, my dad taught me that you never help with that and you never mention it, because then you get bill for making the trust and you get the bill for the probate. And so
It's
why
a
would
two for one, guys. 2 for 1.
2 for 1. And I listened to that and I said, well, thank you so much for your time. Click. I'm never sending a family that way. And on the reverse, we've been sending families to CJ for his jurisdiction, and it was wonderful to hear him talk to families and hear stories from families that he sat and talked to for a long period of time and answered their questions when there's no way that they were going to be a client of his. But that's what we're trying to find, resources for families where they can go and get some answers and get some reasonable help when these legal events are triggered, right? Like probate. So anything else you want to tell us about Copper Canyon or yourself?
You know what? Yeah, I mean, I'm the owner of Copper Canyon Law. I head up the estate planning and probate division. And you know what? Even just like Matt said, if anyone listening, I tell everyone I'm a lawyer and I hate lawyers. So if you want just some real raw gritty answers that no one will tell you, that Google is not helping you with, I'm always happy to give that to you. I have noticed if you go on YouTube and you look up how to unclog a toilet, there will be a plumber on there that will show you how to unclog it. And here's the crazy thing: you're still gonna call a plumber, right? You do. And I'm okay giving you all the secrets and the tips and the tricks. I have faith that people still call me. They want to hire an honest lawyer every once in a while, and I'm willing to give you those answers. So. And I would do that for the Full Circle Aftercare team any day of the week. So if anyone wants or needs help, get in contact with us. We'll get you the answers you need. Always happy to do it.
Yeah. Thank you so much.
Mm-hmm.
So look, we're here for families as well. So any families that you know of who have lost a loved one, we're here to help with the non-legal estate closure of, making notifications, finding what there is to do. And then when the case arises, we're going to help them find, everything from a tax advisor to a financial planner to a lawyer when they need those professional services. And we are just so grateful for all that Copper Canyon Law has done for the families we've sent over. Look, when probate and estate planning, they're things that nobody wants to think about, nobody wants to deal with, but so necessary. And my advice to anyone out there, please do the estate plan first and make sure it's done correctly so that you don't have to worry about the back end, or your family doesn't have to worry about that back end. Looks like we just got a question here. CJ mentioned putting life insurance and bank accounts in the trust, but if the person prefers to put beneficiaries on those types of assets instead of transferring to the trust, is that okay?
Awesome question. Such a good question. And by the way, if anyone out here thinks they're being creative and like having light bulb moments, I promise you I've had those same light bulb moments. So I remember asking that same exact question when I was coming up in the industry. Like, that doesn't make any sense. Here's what you got to be careful of. 2 big things. There's always a good, better, and best option in life, right? Beneficiary forms are awesome. They are such a good option, okay? However, there's 2 little things you got to be careful of. One, you're assuming that person is going to survive you, which I can't tell you how many probates we open because mom died and her son had died from cancer 5 years earlier, or heaven forbid, mom was visiting her daughter in Texas and they got in a car wreck together and died together. Well, all of those beneficiary forms that you put in place have now failed, right? And so now we have to go to probate. So beneficiary forms are awesome, assuming that you keep those meticulously up to date, right? So we got to keep those meticulously up to date, and that person survives you. And one last issue that you have to remember is remember, if you name anybody on a beneficiary form, they are going to receive that share whether you want them to or not. And you say, what are you talking about? Well, in our trust that we prepare for people, if your beneficiary has creditors coming after him, do you think he wants to inherit your life insurance? No. If your son has a special need and is on government needs-based assistance, do you think he wants to be inheriting your life insurance? No. You'll boot him off of all of his benefits. If your son is going through a brutal divorce, do you think he wants to be inheriting money right in the middle of his divorce? No. What if your daughter has a substance abuse problem? You want her getting money right in the middle of her drug addiction? No. Well, guess what?
Jail.
If you, or in jail, or you have a 16-year-old grandson that's about to inherit $500,000. Do you want your 16-year-old grandson getting $500,000? No. So these are all scenarios where you do not want to name that person on a life insurance policy, on a checking account beneficiary form. And yet, I guarantee anyone listening to this right now, you know someone who has those things going on. We all do. We all have someone in our life that has a substance abuse problem, special needs, all those things, creditor issues, divorce. If you name people as a beneficiary on those things, they are going to get it no matter what. And that is the worst thing that could happen to them. So what's the alternative? The alternative, have it pay out to a trust. And then the trust holds it, and it's a credit shelter for your grandson, for your son. I just had a guy come to me and said, hey, my dad left me 4 commercial properties. The value is over $2 million. I said, okay. And he goes, I'm right in the middle of a bankruptcy. He goes, I cannot get these properties to hit my name. I looked into it. They were all being held in a trust. And I said, dude, this is your lucky day. And he goes, what? I said, we're just going to let them sit in this trust. And he goes, I can do that? I said, yes, just let them sit there. Let your bankruptcy wrap up in 3, 4, 5 years from now. We're going to distribute those outright to you once all the creditor claims are gone. He goes, this trust literally just saved me $2 million. I said, I know it. And he goes, this is amazing. And he told me, he goes, my life was hunky-dory my whole life. And then all of a sudden things turned drastically with my business and I filed bankruptcy. My father never would have guessed in a million years I would have been in this scenario. Thankfully, he had the foresight to set that trust up just in case anything like that happened. That's why beneficiary forms can be a little tricky. Like, they're great unless they're not. Yeah.
Right.
Absolutely.
Love it. Nikki, anything else you want to add?
No, other than thank you, CJ.
Of course.
We appreciate everything you do for every family we send to you. And you are an amazing resource for us, and we appreciate you.
Anytime. I'd do anything for you guys.
Yeah. Thank you so much for coming on, for helping families, and for just the information that you've given us today. So helpful. If you are in Arizona, definitely call CJ, Copper Canyon Law, or any of his team members. I think other team members have been wonderful with their families as well that we've referred over there. If you have any questions for us, please do not hesitate to reach out to me or to Nikki. Our contact info is there on the screen. And I guess we have an SBA Live coming up in about 2 weeks. Is that right?
Yeah, August 15th at 1 p.m. That's Mountain Time, 1 p.m. And that will be how aftercare can help improve funeral home and hospice marketing.
Right.
So,
okay, we'll see you on the 15th. Thanks so much, everyone.
Okay.
Thanks,
Thank
guys.
you.